Question 1. Market research demonstrates that the real estate market in a specific Ontario community has experienced significant price appreciation over the past 2 years, coinciding with a period of low interest rates and strong local employment growth. However, recent economic forecasts suggest a potential slowdown in national economic growth and a possible increase in interest rates over the next 18 months. As a real estate broker advising a client on whether to purchase a property in this community, which of the following approaches best reflects professional due diligence and ethical practice under Ontario's real estate regulations? Option A. Emphasize the recent rapid price appreciation as a strong indicator of continued future growth, advising the client that the market is likely to remain robust regardless of broader economic shifts. Option B. Advise the client to proceed with the purchase immediately, citing the low interest rates as the primary driver of value, and suggesting that any potential economic slowdown will be temporary and unlikely to impact this specific community's property values significantly. Option C. Present a comprehensive market analysis that includes current supply and demand, recent sales data, local economic indicators, and discusses how projected national economic trends and potential interest rate changes might influence the local market, enabling the client to make an informed decision. Option D. Recommend delaying the purchase until the economic outlook becomes clearer, focusing solely on the potential negative impacts of forecasted interest rate increases and economic slowdown, without providing a balanced view of current market strengths. Correct answer is C. Present a comprehensive market analysis that includes current supply and demand, recent sales data, local economic indicators, and discusses how projected national economic trends and potential interest rate changes might influence the local market, enabling the client to make an informed decision. Explanation. Scenario analysis. This scenario presents a professional challenge for a real estate broker in Ontario due to the inherent volatility of real estate markets and the significant impact of economic factors. A broker must navigate these complexities while upholding their fiduciary duties to clients and adhering to the Real Estate and Business Brokers Act, 2002, REBA 2002, and its associated regulations. The challenge lies in providing accurate, unbiased advice that considers both current market conditions and future economic trends, without making speculative guarantees or misrepresenting potential outcomes. Careful judgment is required to balance client expectations with realistic market assessments. Correct approach analysis. The best professional approach involves conducting thorough market research that analyzes current supply and demand dynamics, recent sales data, and local economic indicators such as employment rates, interest rate trends, and population growth projections within the specific Ontario region. This approach prioritizes providing clients with a comprehensive, data-driven overview of the market's current state and potential future influences, enabling them to make informed decisions. This aligns with the ethical obligation under REBA 2002 to act with honesty, integrity, and in the best interests of the client, which includes providing accurate and relevant information. It also reflects the duty to be knowledgeable about the market. Incorrect approach is analysis. Focusing solely on recent rapid price appreciation without considering underlying economic fundamentals or potential market corrections is an ethically unsound approach. This could lead to misrepresentation of future market performance and potentially encourage clients to make decisions based on unsustainable trends, violating the duty to provide accurate information and act in the client's best interest. Making definitive predictions about future property values based on a single economic indicator, such as an anticipated interest rate change, without a broader analysis of interconnected economic factors and market sentiment, is also professionally deficient. This oversimplifies complex market dynamics and risks misinforming the client, potentially leading to poor investment decisions and a breach of professional duty. Recommending a course of action based primarily on anecdotal evidence or personal speculation about future economic conditions, rather than objective market data and analysis, is unacceptable. This approach lacks the rigor required by REBA 2002 and can expose clients to significant financial risk due to unsubstantiated advice. Professional reasoning. Professionals should adopt a decision-making framework that begins with a comprehensive understanding of the client's objectives. This is followed by rigorous data collection and analysis, focusing on both current market conditions and relevant economic factors specific to the Ontario jurisdiction. The analysis should be objective, unbiased, and consider a range of potential future scenarios. Advice should then be communicated clearly to the client, outlining the basis for the assessment and empowering them to make informed decisions, rather than making definitive predictions or recommendations based on incomplete information. Question 2. The assessment process reveals that a married couple in Ontario wishes to purchase a residential property together. They express a desire to own it together and have indicated that if one of them passes away, the other should automatically become the sole owner of the property. They have also mentioned that they want to ensure their individual contributions to the down payment are clearly reflected in their ownership shares. Considering these statements and the principles of Ontario property law, which of the following approaches best guides the registrant's advice and actions? Option A. Advise the clients that as a married couple purchasing property together, joint tenancy is the most appropriate form of ownership and proceed with registering the title accordingly, as this typically aligns with spousal ownership. Option B. Recommend tenancy in common with equal shares, explaining that this allows for clear individual ownership and avoids the automatic survivorship of joint tenancy, which might complicate estate planning if they have different beneficiaries in mind. Option C. Fully explain the concepts of joint tenancy and tenancy in common, highlighting the right of survivorship inherent in joint tenancy and the ability to specify unequal or equal shares in tenancy in common, and then allow the clients to make an informed decision based on their stated preferences and future intentions. Option D. Suggest leasehold ownership, explaining that this allows them to occupy and use the property together for a specified period, and that upon the end of the lease, they can decide on future arrangements. The correct answer is C. Fully explain the concepts of joint tenancy and tenancy in common, highlighting the right of survivorship inherent in joint tenancy and the ability to specify unequal or equal shares in tenancy in common, and then allow the clients to make an informed decision based on their stated preferences and future intentions. Explanation. The scenario presents a common challenge in real estate transactions in Ontario, distinguishing between different forms of ownership and advising clients accurately based on their stated intentions and the legal implications. Misunderstanding or misrepresenting these ownership types can lead to significant legal disputes, financial losses, and damage to a registrant's professional reputation. The core difficulty lies in translating a client's informal understanding of owning together into the precise legal framework of Ontario property law. The best approach involves clearly explaining the implications of each ownership type to the clients, allowing them to make an informed decision based on their specific circumstances and future intentions. This means detailing how each form of ownership handles survivorship rights, the ease of selling or transferring their interest, and how their respective shares are treated upon death or in case of debt. This aligns with the Real Estate and Business Brokers Act, 2002, REBA, and its associated Code of Ethics, which mandate that registrants provide competent service, act with integrity, and avoid conduct that would bring the profession into disrepute. Specifically, registrants must ensure clients understand the nature of the transaction and the legal implications of their choices. An incorrect approach would be to assume the clients mean joint tenancy simply because they are a married couple and wish to own property together. This overlooks the possibility that they might prefer the flexibility of tenancy in common, perhaps for estate planning reasons, or to ensure their individual interests are clearly defined and transferable independently. Failing to explore these nuances and present the options comprehensively violates the duty of care and the obligation to provide informed advice. Another incorrect approach would be to advise them to simply register the title as joint tenants without a thorough discussion of the implications, especially regarding the right of survivorship. This bypasses the crucial step of ensuring the clients understand that in joint tenancy, the surviving owner automatically inherits the deceased owner's share, which may not align with their individual wishes for their estate. Finally, advising them to proceed with leasehold ownership would be fundamentally incorrect if their intention is to acquire outright ownership of the property. Leasehold involves renting property for a fixed term, not owning it outright, and would not fulfill the client's stated desire to own it together. This demonstrates a severe misunderstanding of basic property ownership concepts and a failure to provide accurate advice. Professionals should employ a decision-making framework that prioritizes client education and informed consent. This involves 1. actively listening to and understanding the client's stated goals and concerns. 2. Clearly defining the legal options available under Ontario law: fee simple, leasehold, joint tenancy, tenancy in common. 3. Explaining the practical implications, rights, and responsibilities associated with each option in plain language. 4. Guiding the client through a comparison of these options based on their stated needs. And 5. Documenting the client's final decision and the advice provided. Question 3. Cost-benefit analysis shows that while representing both a buyer and a seller in the same transaction in Ontario can increase a brokerage's revenue, it also introduces significant ethical and legal complexities. Considering the regulatory framework governing real estate professionals in Ontario, what is the most appropriate course of action for a registered real estate broker who is representing a seller and discovers that their client's property is of strong interest to a buyer whom the broker also represents? Option A. Inform the seller that the broker represents the buyer and advise the seller to reject the buyer's offer due to the conflict of interest, without exploring dual representation. Option B. Inform the seller of the buyer's interest and the broker's representation of the buyer, but proceed with negotiations without obtaining explicit written consent for dual representation, relying on the seller's implied understanding. Option C. Immediately disclose to both the seller and the buyer, in writing, that the broker represents both parties, explain the implications of dual representation, and obtain informed written consent from both parties before proceeding with any negotiations or further actions. Option D. Proceed with negotiations on behalf of the buyer with the seller, without disclosing the broker's representation of the buyer to the seller, assuming the seller is aware of the broker's general role. The correct answer is C. Immediately disclose to both the seller and the buyer, in writing, that the broker represents both parties, explain the implications of dual representation, and obtain informed written consent from both parties before proceeding with any negotiations or further actions. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a broker to balance the fiduciary duty owed to a client with the legal and ethical obligations under Ontario's real estate legislation. Misinterpreting or misapplying the principles of agency and disclosure can lead to significant legal repercussions, disciplinary action from the Real Estate Council of Ontario, RECO, and damage to the broker's reputation. The broker must navigate potential conflicts of interest and ensure all parties are treated fairly and transparently, adhering strictly to the Real Estate and Business Brokers Act, 2002, REBA 2002, and its associated Code of Ethics. Correct approach analysis. The best professional practice involves the broker proactively disclosing their agency relationship and the potential for dual representation to both parties in writing, as soon as the possibility arises. This approach aligns with the fundamental principles of agency law and the disclosure requirements mandated by REBA 2002. Specifically, Section 17 of REBA 2002 and the Code of Ethics require registrants to disclose to all parties in a transaction any relationship or interest that might affect their duty to any party. Obtaining informed consent from both parties to proceed under dual representation, with a clear understanding of the broker's limited ability to advocate for each party's individual interests, is paramount. This ensures transparency, upholds fiduciary duties to the extent possible under dual representation, and complies with regulatory expectations for fair dealing. Incorrect approaches analysis. One incorrect approach involves proceeding with the transaction without informing the seller about the buyer's interest and the broker's representation of the buyer. This failure constitutes a breach of the broker's fiduciary duty to the seller and violates the disclosure requirements under REBA 2002. It creates an undisclosed conflict of interest and undermines the principle of fair dealing. Another incorrect approach is to inform the seller of the buyer's interest, but proceed without obtaining explicit written consent for dual representation. While disclosure is a step in the right direction, proceeding without formal consent for dual agency, especially when the broker is actively negotiating on behalf of the buyer, can still lead to perceived or actual breaches of duty. The Code of Ethics emphasizes the need for informed consent when conflicts arise. A further incorrect approach is to advise the seller to reject the buyer's offer outright due to the conflict, without exploring the possibility of dual representation with full disclosure and consent. While a broker can advise their client, unilaterally preventing a transaction that could be mutually beneficial, without first attempting to manage the conflict through proper disclosure and consent procedures, may not be in the client's best interest and could be seen as an overreach of the broker's authority to manage potential conflicts. Professional reasoning. Professionals should adopt a proactive and transparent approach when faced with potential dual representation. The decision-making process should begin with identifying the potential conflict of interest. This should be immediately followed by a thorough review of REBA 2002 and the Code of Ethics regarding disclosure and agency. The next step is to communicate the situation clearly and in writing to both parties, explaining the implications of dual representation and the broker's role. Obtaining informed, written consent from both parties is crucial before proceeding. If consent cannot be obtained or if the conflict is too significant to manage ethically, the professional should consider withdrawing from representing one or both parties. This structured approach ensures compliance, protects all parties, and upholds professional integrity. Question 4. During the evaluation of a proposed residential lease agreement for a property in Toronto, Ontario, a real estate broker identifies a clause stating that the tenant agrees to pay a non-refundable administrative fee of $200 if they wish to terminate the lease agreement for any reason with 30 days' notice. Considering the Residential Tenancies Act, 2006, how should the broker advise their landlord-client regarding the enforceability of this clause? Option A. Advise the landlord that the clause is enforceable, but the tenant must provide 60 days notice instead of 30 days, as this is a more standard notice period for lease terminations in Ontario. Option B. Advise the landlord that this clause is likely void and unenforceable under the Residential Tenancies Act, 2006, as it attempts to create a penalty for early termination that is not permitted and may infringe upon the tenant's statutory rights regarding lease termination. Option C. Advise the landlord that the clause is enforceable as long as it is clearly written and signed by both parties, as freedom of contract generally allows parties to agree to such terms. Option D. Advise the landlord that the clause is enforceable and can be applied to any lease termination, including those initiated by the landlord for cause, as it is a mutually agreed-upon fee. The correct answer is B. Advise the landlord that this clause is likely void and unenforceable under the Residential Tenancies Act, 2006, as it attempts to create a penalty for early termination that is not permitted and may infringe upon the tenant's statutory rights regarding lease termination. Explanation. During the evaluation of lease agreements in Ontario, real estate professionals often encounter situations where the terms and conditions require careful interpretation to ensure compliance with the Residential Tenancies Act, 2006, RTA, and to protect the interests of both landlords and tenants. This scenario is professionally challenging because a misunderstanding or misapplication of lease clauses can lead to disputes, legal action, and damage to a registrant's reputation and license. The core of the challenge lies in distinguishing between standard lease provisions and those that may be void or unenforceable under Ontario law. The best approach involves a thorough understanding of the RTA's provisions regarding lease terms, specifically identifying clauses that are prohibited or that attempt to override statutory rights. This means recognizing that while parties can agree to terms, these agreements cannot contravene the RTA. For instance, a lease clause that purports to waive a tenant's right to proper notice for entry or to charge arbitrary fees not permitted by the RTA would be considered void. A registrant's duty is to advise clients on the enforceability of lease terms within the Ontario legal framework, ensuring that the lease agreement aligns with the RTA. This proactive stance prevents future complications and upholds professional integrity. An incorrect approach would be to assume all clauses in a lease agreement are legally binding simply because they are written and signed. For example, including a clause that requires a tenant to forfeit their entire security deposit if they break the lease early, without adhering to the RTA's provisions on rent arrears or lawful termination, is a regulatory failure. The RTA dictates specific procedures and limitations on security deposits and lease terminations, and any clause attempting to circumvent these is void. Another failure would be to advise a landlord that a clause requiring tenants to pay for all repairs, regardless of cause or extent, is enforceable. The RTA places responsibility for certain repairs on the landlord, and a lease cannot shift this statutory obligation entirely to the tenant. Such advice would be contrary to the RTA and could lead to significant legal repercussions for both the landlord and the registrant. Professionals should employ a decision-making process that prioritizes regulatory compliance and ethical conduct. This involves 1. Familiarizing oneself thoroughly with the RTA and its implications for lease agreements. 2. Critically reviewing all proposed lease clauses for compliance with the RTA. 3. Advising clients on the enforceability of specific clauses, highlighting any that may be void or unenforceable. 4. Documenting advice provided to clients regarding lease terms. 5. Seeking clarification from regulatory bodies or legal counsel when uncertain about the interpretation or application of specific RTA provisions. Question 5. In Ontario, what factors determine the enforceability of a real estate agreement where the written contract contains an ambiguous statement regarding the purchase price, and the parties have not yet executed a formal written addendum to clarify it? Option A. The presence of a clear and unequivocal meeting of the minds on the essential term of price, as evidenced by the written agreement or subsequent written clarification, and the objective determinability of the price. Option B. The assumption that the contract is automatically void due to any ambiguity in the price, without further investigation into potential subsequent agreements or conduct. Option C. The mere fact that a written agreement has been signed by both parties, regardless of the clarity of the price term. Option D. The existence of a verbal agreement between the parties that clarifies the intended purchase price, even if it is not reflected in the written contract. Correct answer is A. The presence of a clear and unequivocal meeting of the minds on the essential term of price, as evidenced by the written agreement or subsequent written clarification, and the objective determinability of the price. Explanation. This scenario is professionally challenging because it requires a real estate professional to navigate the enforceability of a contract when a key element, the agreement on price, is ambiguous. Misinterpreting the enforceability of such an agreement can lead to significant legal and financial repercussions for both the buyer and seller, as well as damage to the professional's reputation and potential disciplinary action from the Real Estate Council of Ontario, RECO. Careful judgment is required to assess whether a binding contract exists under Ontario law. The best professional approach involves a thorough review of the written agreement and any supporting documentation to determine if there was a clear and unequivocal meeting of the minds on the essential term of price. This requires understanding the principles of contract formation under Ontario's common law, which dictates that for a contract to be enforceable, there must be an offer, acceptance, consideration, and an intention to create legal relations, with all essential terms being sufficiently certain. In this case, the ambiguity surrounding the price is the critical factor. If the written agreement, or a subsequent written addendum, clearly specifies the price, or provides a mechanism for its objective determination, then the contract is likely enforceable. If the price remains vague or subject to further negotiation without a defined process, it may be deemed unenforceable due to lack of certainty. This approach aligns with the Real Estate and Business Brokers Act, 2002, REBA, and its associated regulations, which mandate that registrants act with honesty, integrity, and professionalism, and ensure that agreements are clear and understandable. An incorrect approach would be to assume enforceability based solely on the existence of a signed document, without scrutinizing the clarity of the essential terms. This fails to acknowledge that a contract requires more than just signatures. It requires a genuine agreement on all material aspects. Relying on a verbal understanding of the price, especially when it contradicts or is not clearly reflected in the written agreement, is also problematic. Ontario law generally requires significant contractual terms to be in writing to be enforceable, and verbal agreements on price in real estate transactions are highly susceptible to disputes and are often difficult to prove. Furthermore, advising a client that a contract is enforceable simply because it was signed, without a proper legal analysis of its terms, constitutes a failure to provide competent advice and could lead to a breach of professional duty under REBA. Another incorrect approach is to suggest that the contract is automatically void because of the price ambiguity, without considering whether the parties have subsequently clarified the price through written addenda or by their conduct. While initial ambiguity can be a barrier to enforceability, subsequent actions or agreements can sometimes cure such defects. To definitively declare a contract void without exploring these possibilities is premature and potentially detrimental to the client's interests. This overlooks the principle that courts may seek to uphold contracts where possible, especially if the parties have demonstrated a clear intention to be bound and have taken steps to resolve any ambiguities. The professional decision-making process for similar situations should involve 1. Identifying the core issue. Is there a clear agreement on all essential terms, particularly price? 2. Reviewing all documentation. Examine the written agreement, any addenda, and relevant correspondence. 3. Applying legal principles. Understand the requirements for contract formation and enforceability under Ontario law. 4. Seeking clarification. If ambiguity exists, advise clients on the need for written clarification or amendment. 5. Consulting legal counsel. For complex or uncertain situations, recommend that clients seek independent legal advice. 6. Acting with due diligence. Ensure all advice provided is accurate, professional, and in compliance with REBA. Question 6. System analysis indicates a landlord in Ontario has instructed their real estate representative to only show a vacant condominium to prospective tenants who are adults and have no children, stating they want a quiet, adult-only environment. Considering Ontario's fair housing laws and anti-discrimination regulations, which of the following represents the most appropriate and legally compliant course of action for the real estate representative? Option A. Inform the landlord that you cannot fulfill their request but do not elaborate on the legal reasons, leaving them to potentially seek advice elsewhere. Option B. Agree to the landlord's request and subtly screen out families with children during showings by asking indirect questions about their lifestyle. Option C. Politely explain to the landlord that their request is discriminatory and violates the Ontario Human Rights Code, and that all prospective tenants must be evaluated based on objective, non-discriminatory criteria, while offering to market the property to all eligible individuals. Option D. Advise the landlord that they can advertise the property as adults only to deter families with children from inquiring. The correct answer is C. Politely explain to the landlord that their request is discriminatory and violates the Ontario Human Rights Code, and that all prospective tenants must be evaluated based on objective, non-discriminatory criteria, while offering to market the property to all eligible individuals. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate professional to navigate a delicate situation involving a potential tenant's protected characteristic and a landlord's stated preferences. The challenge lies in balancing the landlord's desire for a specific tenant profile with the absolute legal obligation to comply with Ontario's fair housing laws and anti-discrimination regulations. Failure to do so can result in significant legal penalties, reputational damage, and harm to individuals seeking housing. Careful judgment is required to ensure all actions are compliant and ethical. Correct approach analysis. The best professional practice involves politely but firmly informing the landlord that their request is discriminatory and violates Ontario's Human Rights Code. This approach directly addresses the discriminatory nature of the request by explaining that refusing to rent based on a protected ground, such as family status, which is implied by the desire for a quiet, adult-only environment when children are not present, is illegal. The professional must then explain that all prospective tenants must be evaluated based on objective, non-discriminatory criteria, such as financial stability and rental history, and that the property must be advertised and shown without regard to protected characteristics. This aligns with the core principles of the Ontario Human Rights Code, which prohibits discrimination in housing based on grounds including family status, age, and other protected characteristics. Incorrect approaches analysis. One incorrect approach involves agreeing to the landlord's request and attempting to subtly screen out families with children during showings or by asking leading questions. This is a direct violation of the Ontario Human Rights Code. It constitutes indirect discrimination by creating barriers or applying criteria that disproportionately disadvantage individuals with a protected characteristic. This approach is ethically reprehensible and legally indefensible. Another incorrect approach is to simply tell the landlord that you cannot fulfill their request without explaining why. While it avoids direct complicity in discrimination, it fails to educate the landlord about their legal obligations and may lead them to seek out less scrupulous agents. It also misses an opportunity to uphold professional standards and promote fair housing practices within the industry. A third incorrect approach is to suggest to the landlord that they can advertise the property as adults only and hope that families with children do not inquire. This is a misinterpretation of the law. while some limited exceptions may exist for specific types of housing, e.g., senior residences. A general, adults-only advertisement for a standard residential property in Ontario is likely to be considered discriminatory based on family status, as it aims to exclude families with children. This approach attempts to circumvent the law rather than comply with it. Professional reasoning. Professionals should employ a decision-making framework that prioritizes legal compliance and ethical conduct. This involves 1. Identifying the protected characteristic or potential for discrimination in a request. 2. Recalling and applying relevant legislation, in this case, the Ontario Human Rights Code. 3. Communicating clearly and professionally with the client about legal obligations and ethical responsibilities. 4. Offering compliant alternatives and guidance. 5. Documenting all communications and decisions. When faced with a request that appears discriminatory, the professional's primary duty is to educate the client and refuse to participate in any discriminatory practice. Question 7. Benchmark analysis indicates that clients often inquire about the suitability of different mortgage structures. In Ontario, a real estate broker is assisting a client who is exploring their financing options for a property purchase and has expressed confusion about fixed rate, adjustable rate, and interest-only mortgages. Which of the following represents the most appropriate and professionally responsible course of action for the broker? Option A. Explain the fundamental differences and repayment structures of fixed rate, adjustable rate, and interest-only mortgages, and strongly advise the client to consult with a licensed mortgage broker or financial advisor for personalized guidance based on their financial situation and goals. Option B. Suggest an interest-only mortgage as a way to maximize cash flow in the short term, without delving into the long-term repayment obligations or the client's ability to manage future principal payments. Option C. Recommend an adjustable rate mortgage, explaining that it is generally a good option for clients who anticipate selling the property within 5 years due to potentially lower initial payments. Option D. Advise the client that a fixed-rate mortgage is always the most secure choice and will protect them from any future interest rate fluctuations, regardless of their financial circumstances. The correct answer is A. Explain the fundamental differences and repayment structures of fixed-rate, adjustable rate, and interest-only mortgages, and strongly advise the client to consult with a licensed mortgage broker or financial advisor for personalized guidance based on their financial situation and goals. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires a real estate broker in Ontario to accurately advise a client on mortgage types without resorting to financial advice, which falls outside the scope of their licensing. The broker must understand the fundamental differences between fixed-rate, adjustable rate, and interest-only mortgages to guide the client towards seeking appropriate professional financial advice, rather than making a recommendation that could be construed as financial planning or advice. The challenge lies in balancing helpfulness with regulatory boundaries. Correct approach analysis. The best professional practice involves clearly explaining the general characteristics of each mortgage type to the client, emphasizing that these are distinct financial products with different risk profiles and repayment structures. The broker should then strongly recommend that the client consult with a qualified mortgage broker or financial advisor to discuss their personal financial situation, risk tolerance, and long-term goals to determine which mortgage type, if any, best suits their needs. This approach respects the regulatory framework in Ontario, which restricts real estate brokers from providing financial advice and ethically directs the client to the appropriate professionals. It empowers the client with basic knowledge while ensuring they receive specialized guidance. Incorrect approaches analysis. Recommending a specific mortgage type, such as suggesting an adjustable rate mortgage is best for someone looking to move in a few years, constitutes providing financial advice. This is a direct violation of Ontario's real estate regulations, which limit the scope of practice for real estate brokers. Similarly, downplaying the risks associated with an interest-only mortgage without a comprehensive understanding of the client's financial capacity and long-term plans is irresponsible and potentially harmful, exceeding the broker's professional mandate. Advising a client that a fixed-rate mortgage is always the safest option is an oversimplification and can be considered financial advice, as the suitability of any mortgage product is highly dependent on individual circumstances and market conditions, which a real estate broker is not licensed to assess. Professional reasoning. Professionals in Ontario's real estate industry must operate within their defined scope of practice. When faced with client inquiries that verge on financial advice, the decision-making process should involve 1. Identifying the client's underlying need, understanding mortgage options. 2. Providing factual general information about the products in question without making recommendations. 3. Clearly delineating the limits of their professional expertise. 4. Directing the client to licensed and qualified professionals, e.g., mortgage brokers, financial advisors, for personalized advice. This ensures client protection and adherence to regulatory requirements. Question 8. Benchmark analysis indicates that a property in rural Ontario features a substantial farmhouse, outbuildings, and 100 acres of land currently under active cultivation for cash crops. The owner intends to sell the property as a whole, emphasizing its agricultural potential. Which classification best reflects this property's primary nature for listing and marketing purposes under Ontario's real estate framework? Option A, commercial. Option B, industrial. Option C, residential. Option D, agricultural. The correct answer is D, agricultural. Explanation: scenario analysis. This scenario presents a professional challenge because it requires a real estate broker in Ontario to accurately classify a property for listing and marketing purposes, which directly impacts the target audience, marketing strategies, and potentially the broker's commission structure and regulatory obligations. Misclassification can lead to misrepresentation, breach of contract, and regulatory noncompliance under Ontario's real estate legislation. Careful judgment is required to ensure the property is categorized according to its primary use and the relevant provisions of the Real Estate and Business Brokers Act, 2002, REBA 2002. Correct approach analysis. The best professional practice involves a thorough assessment of the property's primary and predominant use, considering its physical characteristics, zoning, and the owner's intended purpose for sale. For a property that includes a dwelling and a significant portion of land actively used for crop production, the broker must determine if the agricultural aspect is incidental to the residential use, or if the agricultural use is the primary driver of the property's value and marketability. In Ontario, properties that are primarily agricultural, even if they contain a residence, are typically classified as agricultural. This approach ensures accurate representation to potential buyers, adherence to REBA 2002 disclosure requirements, and alignment with the specialized marketing required for agricultural properties. Incorrect approaches analysis. Classifying the property solely as residential, despite the substantial acreage and active farming operations, would be an ethical and regulatory failure. This misrepresentation could mislead buyers seeking agricultural land, potentially leading to contractual disputes and a breach of the duty of honesty and integrity mandated by REBA 2002. It also fails to leverage specialized marketing channels appropriate for agricultural properties, potentially disadvantaging the seller. Classifying the property as commercial would be incorrect if the primary use is not for business operations that generate revenue beyond agricultural production, such as a retail farm stand or processing facility. While some agricultural operations can be considered commercial, the core of the property's current use appears to be crop production, not a distinct commercial enterprise. This misclassification would attract the wrong type of buyer and marketing efforts. Classifying the property as industrial is clearly inappropriate. Industrial properties are typically characterized by manufacturing, processing, or warehousing activities, which are not described as the primary use of this property. This classification would be a gross misrepresentation of the property's nature and would violate fundamental ethical obligations. Professional reasoning. Professionals should adopt a systematic approach to property classification. This involves 1. Understanding the client's objectives and the property's current use. 2. Reviewing property documentation, including zoning bylaws and any existing agricultural designations. 3. Physically inspecting the property to assess its features and predominant use. 4. Consulting with relevant experts if necessary, e.g., agricultural appraisers. 5. Applying the definitions and principles of property types as understood within the Ontario real estate market and under REBA 2002. The goal is always to provide accurate and transparent information to all parties involved. Question 9. Benchmark analysis indicates that the Ontario real estate market is experiencing shifts. A client, who is a first-time homebuyer, is seeking your advice on whether to purchase now or wait. Considering the principles of responsible real estate practice in Ontario, Which of the following approaches best guides your advice to the client? Option A, guaranteeing the client that prices will continue to rise rapidly in the next 12 months and encouraging them to secure financing immediately to capitalize on this expected appreciation. Option B, presenting a balanced overview of current market conditions in their specific Ontario region, discussing factors like interest rates, inventory levels, and employment trends, and explaining that while predicting precise future movements is impossible, you can outline potential scenarios based on this data. Option C, focusing exclusively on historical sales data from the past 5 years in their desired Ontario neighborhood, without incorporating current economic indicators or future projections. Option D, advising the client that a significant market downturn is imminent and urging them to delay their purchase until prices stabilize, based on a generalized interpretation of national economic indicators. The correct answer is B, presenting a balanced overview of current market conditions in their specific Ontario region, discussing factors like interest rates, inventory levels, and employment trends, and explaining that while predicting precise future movements is impossible, you can outline potential scenarios based on this data. Explanation: scenario analysis. This scenario is professionally challenging because it requires a real estate broker in Ontario to navigate market fluctuations and advise clients effectively without resorting to speculative or misleading practices. The broker must balance the client's desire for profit with the ethical and regulatory obligations to provide accurate, unbiased information. Misinterpreting or misrepresenting market trends can lead to significant financial losses for clients and reputational damage for the broker, potentially violating the Real Estate and Business Brokers Act, 2002, REBA 2002, and its associated code of ethics. Correct approach analysis. The best professional practice involves conducting a thorough, objective analysis of current and historical market data specific to the Ontario region, considering factors like interest rates, employment figures, population growth, and inventory levels. This approach aligns with the duty of care owed to clients under REBA 2002, which mandates that registrants act with integrity and competence. Providing clients with a balanced overview of potential market shifts, including both opportunities and risks, allows them to make informed decisions. This involves explaining that real estate cycles are complex and influenced by numerous variables, and that predicting precise future movements is impossible. The focus should be on educating the client about the current market context and potential scenarios, rather than making definitive predictions. Incorrect approach is analysis. Advising clients that a significant downturn is imminent and urging them to sell immediately, based on a generalized interpretation of national economic indicators without specific local data, fails to meet the standard of care. This approach may be speculative and could lead to a client making a decision that is not in their best interest, potentially violating the duty to be honest and truthful. Suggesting that the market is guaranteed to experience rapid appreciation in the short term and encouraging clients to invest heavily based on this prediction is also problematic. This constitutes making a guarantee or promise regarding future market performance, which is unethical and potentially a breach of REBA 2002, as it misrepresents the inherent uncertainties of real estate cycles. Focusing solely on past performance data without considering current economic conditions or future projections is an incomplete analysis. While historical data is valuable, it does not guarantee future results and can be misleading if not contextualized within the broader economic landscape of Ontario. This approach lacks the forward-looking perspective necessary for comprehensive client advice. Professional reasoning. Professionals should approach market trend analysis by prioritizing objectivity, thoroughness, and client education. This involves 1. Gathering comprehensive localized data. 2. Analyzing multiple influencing factors, not just one or two. 3. Presenting a balanced view of potential outcomes, acknowledging both positive and negative scenarios. 4. Clearly communicating the inherent uncertainties of market forecasting. 5. Ensuring all advice is grounded in factual analysis and ethical considerations, avoiding speculation or guarantees. Question 10. Process analysis reveals that a real estate brokerage in Ontario is seeking to optimize its tenant screening process to ensure responsible tenant selection while adhering to provincial regulations. The brokerage has identified several potential screening strategies. Which of the following strategies represents the most compliant and effective approach for evaluating prospective tenants? Option A. Relying primarily on subjective impressions and gut feelings during interviews to determine a prospective tenant's suitability, without extensive verification of financial capacity. Option B. Prioritizing applicants based on their perceived social status, such as their profession or the make of their vehicle, to gauge their financial responsibility. Option C. Inquiring about prospective tenants' family plans, marital status, and likelihood of having children to assess long-term tenancy stability. Option D. Verifying prospective tenants' income through pay stubs and employment letters, conducting credit checks, and obtaining rental history references from previous landlords. The correct answer is D. Verifying prospective tenants' income through pay stubs and employment letters, conducting credit checks, and obtaining rental history references from previous landlords. Explanation. Scenario analysis. This scenario presents a common challenge for real estate professionals in Ontario, balancing the landlord's need to secure a reliable tenant with the legal and ethical obligations to avoid discriminatory practices during tenant screening. The challenge lies in developing objective criteria that predict a tenant's ability to meet their lease obligations without inadvertently or intentionally discriminating based on protected grounds under the Ontario Human Rights Code. Missteps can lead to significant legal repercussions, reputational damage, and a breach of professional conduct. Correct approach analysis. The best approach involves establishing clear, objective, and consistently applied screening criteria that directly relate to a prospective tenant's ability to fulfill the terms of the lease agreement. This includes verifying income through pay stubs or employment letters, checking credit reports, and obtaining rental history references from previous landlords. These criteria are directly tied to financial capacity and past tenancy performance, which are legitimate indicators of a tenant's likelihood to pay rent and maintain the property. This method aligns with the principles of fairness and non-discrimination by focusing on quantifiable and verifiable factors, thereby minimizing the risk of subjective bias. Incorrect approaches analysis. An approach that involves asking prospective tenants about their family plans or marital status is ethically and legally flawed. Such inquiries delve into personal circumstances that are protected grounds under the Ontario Human Rights Code, specifically family status and marital status. Basing screening decisions on assumptions about future rental behavior related to family size or stability is discriminatory and can lead to legal challenges. Another incorrect approach is to prioritize applicants based on their perceived social standing or lifestyle, such as their profession or the type of car they drive. These are subjective and potentially discriminatory factors that have no direct bearing on a tenant's ability to pay rent or maintain the property. This method opens the door to unconscious bias and can result in the exclusion of qualified candidates based on irrelevant and protected characteristics. Finally, an approach that relies heavily on subjective impressions or gut feelings about a candidate without objective verification of their financial capacity or rental history is also professionally unsound. While intuition can play a minor role, it should never supersede objective data. Relying solely on subjective impressions can mask underlying biases and lead to decisions that are not defensible under fair housing principles. Professional reasoning. Professionals in Ontario must adopt a systematic and objective tenant screening process. This involves 1. Developing a standardized application form that requests only relevant information. 2. Establishing objective screening criteria, e.g., income verification, credit checks, rental history, that are applied equally to all applicants. 3. Training oneself and any staff on the Ontario Human Rights Code and fair housing practices to understand prohibited grounds of discrimination. 4. Documenting all screening decisions and the rationale behind them, ensuring that the documentation supports objective criteria. 5. Consulting with legal counsel or regulatory bodies if there are any uncertainties regarding screening practices. Question 11. Benchmark analysis indicates that in Ontario, when a seller's real estate broker is assisting a buyer with a mortgage application process to facilitate a sale, what is the most ethically sound and legally compliant approach to ensure the buyer secures financing while upholding the broker's professional obligations? Option A. The broker should recommend a specific mortgage lender with whom they have a pre-existing relationship. Submit the mortgage application on behalf of the buyer using their best estimate of the buyer's financial situation and liaise with the lender to expedite approval. Option B. The broker should guide the buyer to select a mortgage lender of their choice, provide accurate property details to the lender as authorized by the buyer, and encourage direct communication between the buyer and the lender for all financial discussions and application submissions. Option C. The broker should strongly encourage the buyer to accept the first mortgage offer presented by a lender, emphasizing the urgency of the real estate transaction and discouraging further negotiation or independent financial review. Option D. The broker should advise the buyer to omit any potentially negative financial information from the mortgage application to increase the chances of approval and assure the buyer that they will handle all communications with the lender. The correct answer is B. The broker should guide the buyer to select a mortgage lender of their choice, provide accurate property details to the lender as authorized by the buyer, and encourage direct communication between the buyer and the lender for all financial discussions and application submissions. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate broker in Ontario to navigate the complexities of mortgage applications while upholding their fiduciary duties to the client and adhering to provincial real estate regulations. The broker must balance the client's desire for a quick sale with the lender's need for accurate and complete information, all while avoiding misrepresentation or undue influence. The potential for conflicts of interest, especially if the broker has a relationship with a specific lender, necessitates a rigorous and transparent process. Correct approach analysis. The best professional practice involves the broker facilitating the client's direct engagement with a mortgage lender of their choice, providing only factual, verifiable information about the property and the transaction, and ensuring the client understands their obligations. This approach aligns with the Ontario Real Estate Association, OREA, Code of Ethics and the Real Estate and Business Brokers Act, 2002, REBA 2002. Specifically, it upholds the duty of honesty and integrity, requires the broker to act in the best interest of the client, and prohibits misrepresentation. By encouraging direct client-lender communication, the broker avoids acting as an unlicensed mortgage broker and ensures the client is making informed decisions with the lender. Incorrect approaches analysis. One incorrect approach involves the broker actively recommending a specific lender and then submitting the mortgage application on behalf of the client, including estimated financial information. This is problematic because it could be construed as providing mortgage brokerage services without the necessary licensing, which is a violation of provincial law. Furthermore, if the broker provides estimated financial information that is inaccurate, even unintentionally, it constitutes misrepresentation, breaching their duty of honesty and integrity. This approach also creates a potential conflict of interest if the broker receives any form of compensation or benefit from the recommended lender. Another incorrect approach is for the broker to advise the client to withhold certain details from the lender that might negatively impact the mortgage approval, such as outstanding debts or a history of financial difficulty. This is a direct violation of the duty to be honest and truthful and to not mislead any party to a transaction. It also undermines the lender's ability to assess risk accurately, potentially leading to a mortgage that the client cannot afford, which is detrimental to the client's best interests. A third incorrect approach is for the broker to pressure the client into accepting a mortgage offer from a particular lender by downplaying the importance of the client's own financial due diligence or by suggesting that the lender's terms are non-negotiable. This constitutes undue influence and fails to ensure the client is making an informed decision, violating the broker's fiduciary duty to act in the client's best interest and to provide them with sufficient information to make sound choices. Professional reasoning. Professionals should approach mortgage application facilitation by prioritizing transparency, client autonomy, and strict adherence to regulatory boundaries. The decision-making framework should involve 1. Clearly defining the broker's role as facilitating the real estate transaction, not the mortgage financing. 2. Educating the client on the mortgage application process and their responsibilities. 3. Encouraging the client to seek independent financial advice and to choose their own mortgage lender. 4. Providing only accurate and verifiable property-related information to the lender upon client consent. And 5. Maintaining a clear separation between real estate brokerage activities and mortgage brokerage activities to avoid any appearance of impropriety or regulatory violation. Question 12. The monitoring system demonstrates that a real estate broker in Ontario is tasked with valuing a historic, purpose-built theater that has been used for live performances for decades. The property has unique architectural features and a niche market, making it difficult to find directly comparable sold properties. Which valuation method should the broker prioritize to ensure an accurate and ethically sound assessment of the property's market value? Option A. The income approach, by analyzing the property's potential to generate revenue from ticket sales, event rentals, and concessions, and applying appropriate capitalization or discount rates. Option B. The cost approach, by estimating the current cost to construct a similar building and subtracting accrued depreciation. Option C. The comparative market analysis, by identifying recently sold properties that are similar in size, age, and location, and adjusting their sale prices to account for differences. Option D. A hybrid approach that equally weights the results of a comparative market analysis and the cost approach, regardless of the property's specific characteristics. The correct answer is A. The income approach, by analyzing the property's potential to generate revenue from ticket sales, event rentals, and concessions, and applying appropriate capitalization or discount rates. Explanation. Scenario analysis. This scenario presents a common challenge for real estate brokers in Ontario, determining the most appropriate valuation method for a unique commercial property. The challenge lies in the property's specific characteristics: a historic, purpose-built theater with limited comparable sales and a niche market. A broker must exercise professional judgment to select a method that accurately reflects the property's value, considering its unique attributes and potential income generation, while adhering to ethical and regulatory standards. Misapplication of a valuation method can lead to inaccurate pricing, potentially harming the client's interests and violating the broker's duty of care under Ontario's Real Estate and Business Brokers Act, 2002, REBA 2002. Correct approach analysis. The most appropriate approach in this scenario is the income approach. This method is best suited for income-generating properties, especially those with unique characteristics where direct comparisons are difficult. The income approach focuses on the property's potential to generate revenue, considering factors like rental income, operating expenses, and market capitalization rates or discount rates. For a historic theater, this approach would involve analyzing its current or potential rental income from performances, events, or even alternative uses, and then applying appropriate financial metrics to derive a value. This aligns with the principles of REBA 2002, which mandates that registrants act with integrity and competence, providing services that are in the best interest of their clients. By focusing on the property's economic potential, the income approach offers a robust valuation for a property that may not have readily available comparable sales data for a comparative market analysis, nor a straightforward replacement cost for the cost approach. Incorrect approaches analysis. Using the comparative market analysis, CMA, as the primary method would be problematic. While CMAs are standard for residential properties, they rely heavily on finding truly comparable sold properties. A historic, purpose-built theater, finding direct comparables with similar age, features, and market appeal would be exceptionally difficult, if not impossible. Relying on dissimilar comparables would lead to an inaccurate valuation, failing the duty of competence and diligence required by REBA 2002. The cost approach, which estimates the cost to replace the property, is also less suitable here. While it can be a useful method for newer, purpose-built properties, applying it to a historic theater presents significant challenges. Accurately estimating the cost to reproduce or replace a unique, historic structure with specialized architectural features and materials would be complex and potentially unreliable. Furthermore, it doesn't directly account for the property's income-generating potential or market demand, which are crucial for a commercial asset. This approach might also fail to capture the property's unique market value, potentially leading to an undervaluation or overvaluation. Professional reasoning. When faced with a unique commercial property, a real estate professional in Ontario should first assess the property's primary function and potential for income generation. If the property is designed to produce income, the income approach should be prioritized. If direct comparables are abundant and reliable, a CMA can be a supporting tool. The cost approach is generally best reserved for newer, functional properties where replacement cost is a reasonable indicator of value. A competent registrant will consider the limitations of each method in relation to the specific property and market conditions, and may even use a combination of approaches, weighting them according to their applicability, to arrive at the most defensible valuation. This professional judgment is crucial for fulfilling the ethical obligations under REBA 2002 to provide accurate and reliable advice. Question 13. Benchmark analysis indicates that a real estate broker in Ontario is assisting a client with a mortgage application. The lender has requested a property appraisal, and the broker has received a copy of the appraisal report. Upon review, the broker notices that the appraised value is significantly lower than the agreed-upon purchase price, potentially jeopardizing the loan approval. What is the most ethically sound and professionally responsible course of action for the broker to take in this situation? Option A. Submit the appraisal report to the lender without disclosing the known discrepancy, hoping the lender overlooks it or approves the loan based on the purchase price. Option B. Proactively communicate the appraisal discrepancy to the lender, explain the situation, and advise the client on potential next steps, such as obtaining a second appraisal or exploring alternative financing options. Option C. Ignore the appraisal discrepancy and proceed with the loan application, assuming the lender will conduct their own independent valuation. Option D. Advise the client to attempt to alter the appraisal report to reflect a higher value that aligns with the purchase price. The correct answer is B. Proactively communicate the appraisal discrepancy to the lender, explain the situation, and advise the client on potential next steps, such as obtaining a second appraisal or exploring alternative financing options. Explanation. Scenario analysis. This scenario presents a common challenge in real estate brokerage where a broker must balance the client's desire for a quick sale with the lender's rigorous underwriting requirements. The professional challenge lies in ensuring that the broker's actions do not mislead the lender or compromise the integrity of the transaction, while still advocating for their client. Ontario's Real Estate and Business Brokers Act, 2002, REBA 2002, and its associated code of ethics place a strong emphasis on honesty, integrity, and avoiding misrepresentation. The broker must navigate these obligations while facilitating a loan approval process that is inherently designed to protect the lender from undue risk. Correct approach analysis. The best professional approach involves proactively identifying potential issues with the property's appraisal and communicating these concerns transparently to the lender, while simultaneously working with the client to explore alternative solutions. This approach aligns with the duty of honesty and integrity mandated by REBA 2002. By acknowledging the appraisal discrepancy and engaging in open dialogue with the lender, the broker demonstrates a commitment to accurate representation. Furthermore, by advising the client on potential next steps, such as seeking a second appraisal or exploring other financing options, the broker fulfills their obligation to act in the best interests of their client within legal and ethical boundaries. This proactive and transparent communication strategy minimizes the risk of misrepresentation and fosters a more trustworthy lending environment. Incorrect approaches analysis. Submitting the appraisal report without disclosing the known discrepancy to the lender constitutes a failure to act with honesty and integrity, violating REBA 2002. This action misrepresents the true value of the property and can lead to the lender approving a loan based on inaccurate information, potentially causing financial harm to both the lender and the client if the property is later found to be overvalued. Suggesting the client doctor the appraisal report to reflect a higher value is a severe ethical and legal breach. This involves deliberate misrepresentation and potentially fraud, which are strictly prohibited under REBA 2002 and could lead to severe disciplinary action, including license revocation. Ignoring the appraisal discrepancy and proceeding with the loan application as if the appraisal were accurate is also professionally unacceptable. This inaction demonstrates a lack of due diligence and a failure to uphold the duty of care owed to both the client and the lender. It allows a potentially flawed transaction to proceed, risking future complications and breaches of trust. Professional reasoning. Professionals in Ontario's real estate industry must prioritize transparency and accuracy throughout the loan underwriting and approval process. When faced with discrepancies, such as an appraisal that does not meet the lender's requirements, the decision-making process should involve 1. Thoroughly understanding the lender's requirements and the implications of the appraisal discrepancy. 2. Openly communicating the issue to the client, explaining the potential consequences. 3. Transparently informing the lender of the discrepancy and any steps being taken to address it. 4. Exploring all legitimate options with the client to resolve the issue, such as obtaining a revised appraisal or seeking alternative financing. 5. Always acting with honesty and integrity, ensuring no misrepresentation occurs. Question 14. Benchmark analysis indicates that effective property maintenance and repair management is crucial for maximizing client returns and minimizing liabilities for real estate brokers in Ontario. Considering the principles of process optimization and fiduciary duty, which of the following strategies best exemplifies a proactive and compliant approach to managing significant property repairs? Option A. Immediately engaging the first available contractor for any repair, identified as urgent to ensure the property is functional as quickly as possible, regardless of cost. Option B. Developing a pre-approved maintenance plan with the property owner that includes a budget for minor repairs and a process for obtaining multiple quotes and written authorization for any repair exceeding a predefined threshold. Option C. Utilizing a contractor recommended by a friend without obtaining alternative bids or informing the property owner of the personal connection. Option D. Deferring non-critical repairs until the property is listed for sale to present a more aesthetically pleasing appearance, even if minor issues could worsen over time. The correct answer is B. Developing a pre-approved maintenance plan with the property owner that includes a budget for minor repairs and a process for obtaining multiple quotes and written authorization for any repair exceeding a predefined threshold. Explanation: this scenario is professionally challenging because it requires a real estate broker in Ontario to balance the immediate need for repairs with the long-term financial implications for the property owner, while adhering to strict disclosure and fiduciary duties. The broker must act in the best interests of the client, which includes ensuring the property is maintained to a reasonable standard, but also managing costs effectively and transparently. Careful judgment is required to avoid unnecessary expenses, ensure compliance with landlord-tenant laws in Ontario, and maintain the property's value and marketability. The best professional practice involves a proactive and documented approach to maintenance and repairs. This includes establishing a clear, written maintenance plan with the property owner that outlines routine tasks, preventative measures, and a pre-approved budget for minor repairs. For significant repairs, the broker should obtain multiple quotes from qualified, licensed contractors, present these to the owner with a professional recommendation, and secure written authorization before proceeding. This approach ensures transparency, cost-effectiveness, and compliance with the broker's fiduciary duty to act in the client's best interest, as well as the requirements under Ontario's Real Estate and Business Brokers Act, 2002, REBA 2002, and its associated Code of Ethics, which mandate acting with honesty, integrity, and competence, and avoiding conduct that is detrimental to the public interest. An approach that involves immediately hiring the first available contractor without obtaining multiple quotes or owner approval for significant repairs is professionally unacceptable. This fails to demonstrate due diligence in securing competitive pricing, potentially leading to overspending, and a breach of the fiduciary duty to manage the client's finances prudently. It also bypasses the owner's right to be informed and make decisions about their property, which is a fundamental ethical obligation. Another unacceptable approach is delaying necessary repairs to avoid immediate costs, especially if these delays could lead to further damage or violate tenant rights under Ontario's Residential Tenancies Act. This demonstrates a lack of competence and could expose the owner to legal liabilities and significant future repair bills, failing to uphold the broker's duty to protect the client's interests. Finally, an approach that involves using a contractor with whom the broker has a personal relationship without disclosing this relationship and obtaining competitive bids is ethically problematic. This raises concerns about potential conflicts of interest and a failure to act in the client's best interest, as the primary consideration should be the quality and cost of the repair, not the broker's personal connections. Professionals should adopt a decision-making framework that prioritizes clear communication, documented processes, and adherence to regulatory requirements. This involves understanding the client's financial goals and risk tolerance, establishing clear contractual agreements for property management, and maintaining a robust system for obtaining bids, authorizing work, and documenting all expenditures. Regular review of maintenance plans and budgets with the owner is also crucial for effective property management and client satisfaction. Question 15. The control framework reveals that a real estate agent in Ontario is representing a seller and has received an offer from a buyer who claims to have secured financing pre-approval. The buyer's agent has verbally confirmed this pre-approval, but no written documentation has been provided. The buyer's agent is eager to have the seller remove the financing condition quickly. What is the most prudent course of action for the seller's agent to ensure their client's interests are protected and regulatory compliance is maintained? Option A. Advise the seller to obtain written confirmation of the buyer's financing pre-approval and recommend the seller engage independent legal counsel to review the agreement of purchase and sale, particularly the financing condition. Option B. Downplay the importance of the financing condition to the seller, suggesting it is a standard clause that can be removed with minimal risk. Option C. Proceed with the sale based on the verbal confirmation of financing pre-approval from the buyer's agent and the agent's personal assessment of the buyer's credibility. Option D. Advise the seller to waive the financing condition immediately to expedite the sale, as the buyer's agent has indicated strong interest. Correct answer is A. Advise the seller to obtain written confirmation of the buyer's financing pre-approval and recommend the seller engage independent legal counsel to review the agreement of purchase and sale, particularly the financing condition. Explanation. The control framework reveals that navigating the complexities of real estate financing in Ontario requires a thorough understanding of both regulatory obligations and ethical responsibilities. This scenario is professionally challenging because it pits the agent's duty to their client against the potential for a quick sale, creating a conflict that demands careful judgment. The agent must prioritize their client's best interests and ensure full disclosure, even if it means a more protracted transaction. The correct approach involves diligently verifying the buyer's financing pre-approval and advising the seller to obtain independent legal counsel to review the agreement of purchase and sale, particularly clauses related to financing. This aligns with the Real Estate and Business Brokers Act, 2002, REBA 2002, and its associated Code of Ethics, which mandate that registrants must treat all parties to a transaction honestly and with integrity, and must not engage in conduct that is dishonest, fraudulent, or otherwise in bad faith. Specifically, REBA 2002 requires registrants to disclose all material facts, and a buyer's financing status is a material fact. Furthermore, advising the seller to seek independent legal advice is a crucial step in ensuring the seller understands their obligations and rights, and that the transaction is conducted in a legally sound manner. This approach upholds the registrant's fiduciary duty to their client. An incorrect approach would be to proceed with the sale based solely on the buyer's verbal assurance of financing and the agent's personal belief in the buyer's credibility. This fails to meet the standard of care required by REBA 2002, which necessitates due diligence in verifying material facts. Relying on a verbal assurance without written confirmation is a significant regulatory failure, as it leaves the seller exposed to the risk of a failed transaction due to financing issues. Another incorrect approach is to downplay the importance of the financing condition to the seller, suggesting it is a mere formality. This is a breach of the duty of honesty and integrity, as it misrepresents a critical aspect of the transaction and fails to disclose a material fact that could significantly impact the seller's decision-making. Finally, advising the seller to waive the financing condition without a clear understanding of the buyer's confirmed ability to secure funds is a direct violation of the registrant's duty to protect their client's interests and could lead to significant financial harm for the seller. Professional decision-making in such situations requires a commitment to transparency, thoroughness, and client advocacy. Agents must always prioritize their client's informed consent and ensure all material facts are disclosed and verified. When in doubt, seeking guidance from their brokerage or legal counsel is paramount. Question 16. Compliance review shows that a real estate broker in Ontario has been approached by a buyer who wishes to purchase a property listed by the broker's own brokerage. The broker has not yet formally agreed to represent the buyer. What is the most appropriate and compliant course of action for the broker to take immediately? Option A. Inform both the seller and the prospective buyer in writing that the broker is considering representing both parties in this transaction. Explain the implications of dual agency and obtain their informed written consent before proceeding with any further representation. Option B. Disclose the potential dual agency only to the seller and proceed with representing the buyer, believing this is sufficient as the seller is aware the property is listed. Option C. Proceed with representing the buyer and attempt to negotiate the sale of the seller's property, assuming the seller will eventually become aware of the dual representation. Option D. Accept the buyer's offer to represent them without any immediate disclosure to either party, and then disclose the dual agency situation only if the buyer makes an offer on the seller's listed property. The correct answer is A. Inform both the seller and the prospective buyer in writing that the broker is considering representing both parties in this transaction. Explain the implications of dual agency and obtain their informed written consent before proceeding with any further representation. Explanation. Scenario analysis. This scenario presents a professional challenge rooted in the dual agency relationship and the potential for undisclosed conflicts of interest. In Ontario, real estate brokers and agents have a fiduciary duty to their clients, which includes acting in their best interests and maintaining confidentiality. When a broker represents both the buyer and the seller in the same transaction, dual agency, the potential for conflicts of interest is heightened. Navigating this situation requires strict adherence to disclosure obligations and ethical practices to ensure fairness and transparency for all parties involved. The challenge lies in balancing the broker's duty to both parties while ensuring neither client is disadvantaged due to the broker's divided loyalties. Correct approach analysis. The best professional practice involves the broker immediately disclosing to both the buyer and the seller that they are considering representing both parties in the transaction. This disclosure must be in writing and clearly outline the implications of dual agency, including the potential limitations on the broker's ability to advocate exclusively for each party's individual interests. The broker must obtain informed consent from both parties before proceeding with dual representation. This approach is correct because it directly aligns with the principles of transparency, informed consent, and the avoidance of undisclosed conflicts of interest, which are fundamental to the Real Estate and Business Brokers Act, 2002, REBA 2002, and its associated Code of Ethics in Ontario. Incorrect approach is analysis. Proceeding with the transaction without any disclosure, assuming the parties will discover the dual representation later, is ethically and legally unacceptable. This failure to disclose violates the broker's duty of honesty and integrity under REBA 2002 and can lead to legal challenges and disciplinary action. Accepting the buyer's offer to represent them without informing the seller of the existing agency relationship, and then attempting to negotiate the sale of the seller's property, creates an undisclosed conflict of interest. This breaches the duty of loyalty owed to the seller and undermines the principle of fair dealing. Only disclosing the dual agency to the buyer and not the seller, or vice versa, is a partial and insufficient disclosure. REBA 2002 mandates full and frank disclosure to all parties involved when a conflict of interest arises or is contemplated. This selective disclosure fails to meet the regulatory requirements for informed consent and fair representation. Professional reasoning. Professionals in Ontario's real estate industry must adopt a proactive and transparent approach to potential conflicts of interest. Decision-making process should prioritize clear, written communication and informed consent from all parties involved. When faced with a situation that could lead to dual agency, the broker should immediately pause, assess the potential conflicts, and initiate a disclosure process. This involves explaining the nature of dual agency, the limitations it imposes on the broker's advocacy, and obtaining explicit, written consent from both the buyer and the seller before proceeding. If informed consent cannot be obtained, or if the conflict is too significant to manage ethically, the broker should decline to represent one or both parties. Question 17. Analysis of an investor's situation in Ontario reveals a strong desire for rapid property acquisition, leading them to inquire about hard money loans and seller financing. As their real estate broker, what is the most prudent and ethically sound approach to advising them on these financing options? Option A. Recommend a hard money loan as the fastest way to secure funds, highlighting its speed without extensively detailing the higher interest rates and shorter terms. Option B. Provide a comprehensive overview of both hard money loans and seller financing, detailing the specific risks, costs, repayment terms, and the critical importance of obtaining independent legal advice for each option. Option C. Advise the investor to proceed with seller financing, emphasizing the potential for flexible terms and omitting the necessity of a formal, legally reviewed agreement. Option D. Focus the discussion solely on the potential for quick returns on investment achievable through these financing methods, downplaying any associated risks or complexities. The correct answer is B. Provide a comprehensive overview of both hard money loans and seller financing, detailing the specific risks, costs, repayment terms, and the critical importance of obtaining independent legal advice for each option. Explanation. Scenario analysis. This scenario presents a professional challenge for a real estate broker in Ontario because it involves advising an investor on financing options that carry significant risks. The broker must navigate the complexities of hard money loans and seller financing, ensuring the investor fully understands the implications and that the broker's advice aligns with their fiduciary duty and regulatory obligations under Ontario's Real Estate and Business Brokers Act, 2002, REBA 2002, and its associated code of ethics. Misrepresenting the nature or risks of these financing methods could lead to severe financial repercussions for the investor and professional discipline for the broker. Correct approach analysis. The best professional practice involves clearly and comprehensively explaining the inherent risks and benefits of both hard money loans and seller financing to the investor. This includes detailing the higher interest rates and shorter repayment terms typical of hard money loans, as well as the potential for foreclosure if payments are missed. For seller financing, it means explaining the importance of a legally sound agreement, the implications of default for both parties, and the need for independent legal advice. The broker must ensure the investor has a thorough understanding of the terms, conditions, and potential consequences of each option before making a decision. This approach upholds the broker's duty of care and disclosure under REBA 2002, ensuring the investor is making an informed decision based on accurate and complete information. Incorrect approach is analysis. Recommending a hard money loan solely based on its speed of funding, without adequately disclosing the significantly higher costs and increased risk of default, is a failure to provide full disclosure and exercise due diligence. This contravenes the broker's obligation to act in the best interest of the client and to avoid misrepresentation. Suggesting seller financing, without emphasizing the critical need for independent legal counsel to draft and review the financing agreement, is negligent. The broker is not providing legal advice, and failing to direct the client to obtain it for such a complex transaction exposes the client to significant legal and financial risks, violating the duty to ensure the client receives appropriate professional advice. Focusing only on the potential for quick profit from a property acquisition using either financing method, while downplaying or omitting the associated risks and costs, constitutes misrepresentation and a breach of the duty to act with integrity and competence. This prioritizes a potential transaction over the client's financial well-being. Professional reasoning. When advising investors on financing options like hard money loans and seller financing, a professional in Ontario must adopt a client-centric approach. This involves a thorough needs assessment, followed by a detailed, transparent explanation of all available options, including their advantages, disadvantages, costs, and risks. The broker must act as an educator and facilitator, empowering the investor to make an informed decision. Crucially, the broker must always recommend that the client seek independent legal and financial advice for complex transactions, as the broker's role is to facilitate the real estate transaction, not to provide legal or financial counsel. This structured approach ensures compliance with REBA 2002 and the Code of Ethics, safeguarding both the client and the broker's professional reputation. Question 18. The review process indicates that a buyer client in Ontario is seeking financing for a property purchase with a down payment of less than 20%. The lender has informed the buyer that private mortgage insurance will be required. What is the most appropriate action for the real estate broker to take in this situation? Option A. Suggest to the buyer that they can negotiate the removal of private mortgage insurance with the lender, as it is an optional cost that can be bypassed if they are willing to accept a slightly higher interest rate. Option B. Clearly explain to the buyer that private mortgage insurance is a requirement of the lender to protect the lender against potential default and is a condition for obtaining the mortgage, ensuring the buyer understands its purpose and cost. Option C. Inform the buyer that private mortgage insurance is a standard part of all mortgage applications and is a fee that cannot be avoided, without detailing its specific purpose or who it protects. Option D. Advise the buyer that the broker will arrange the necessary private mortgage insurance to secure their mortgage approval, implying the broker is facilitating this for the buyer's benefit. Correct answer is B. Clearly explain to the buyer that private mortgage insurance is a requirement of the lender to protect the lender against potential default and is a condition for obtaining the mortgage, ensuring the buyer understands its purpose and cost. Explanation. The review process indicates that understanding the implications of private mortgage insurance, PMI, in Ontario real estate transactions is crucial for brokers. This scenario is professionally challenging because it requires a broker to navigate the complexities of mortgage financing, lender requirements, and consumer protection regulations without misrepresenting the nature or necessity of PMI. Brokers must ensure clients fully comprehend what PMI is, why it might be required by a lender, and that it is distinct from other forms of insurance. The correct approach involves clearly and accurately explaining to the client that private mortgage insurance is a requirement imposed by the lender, not the real estate broker, and that its purpose is to protect the lender against potential default on the mortgage. This explanation should emphasize that the cost of PMI is passed on to the borrower, and that it is a condition for obtaining mortgage approval from certain lenders, particularly for borrowers with a down payment below a specific threshold. This aligns with the ethical obligation of a real estate professional to provide clear, accurate, and unbiased information to clients, ensuring they make informed decisions. It also adheres to the principles of transparency and fair dealing mandated by real estate regulations in Ontario. An incorrect approach would be to present PMI as a mandatory insurance product that the broker is arranging for the client's benefit, or to imply that the broker has discretion in requiring it. This misrepresents the nature of PMI, which is a lender-driven requirement, failing to clarify that PMI protects the lender, not the borrower, and is a condition of the mortgage itself, constitutes a failure to provide accurate information and could mislead the client about their financial obligations and the purpose of the insurance. Another incorrect approach would be to downplay the cost or significance of PMI, suggesting it is a minor administrative fee. This would violate the duty of full disclosure and could lead to the client being financially unprepared for this additional expense, potentially impacting their ability to secure financing or manage their mortgage payments. Professionals should adopt a decision-making framework that prioritizes client understanding and informed consent. This involves proactively identifying potential areas of confusion, such as mortgage insurance, and preparing clear, concise explanations. Brokers should always err on the side of overcommunication when it comes to financial aspects of a transaction, ensuring clients are aware of all costs, conditions, and the purpose of any required insurance products. If unsure about a specific aspect of mortgage financing or insurance, seeking clarification from the lender or a mortgage professional is a responsible step. Question 19. Performance analysis shows that the Ontario real estate market has experienced significant appreciation over the past decade, but recent economic indicators suggest a potential shift, including rising interest rates and increased inflation. A client, eager to capitalize on perceived continued growth, is asking for your advice on whether to purchase an investment property now or wait. Which of the following represents the most responsible and ethically sound approach for a registered real estate broker in Ontario? Option A suggests that the client delay their purchase indefinitely until economic conditions are perceived to be more favorable, without providing any concrete analysis of current or future market possibilities. Option B recommend that the client ignore the current economic indicators, as they are often short-term fluctuations, and proceed with the purchase based on anecdotal evidence of strong past performance. Option C advise the client to purchase the investment property immediately, emphasizing the historical trend of market appreciation and assuring them that the market will inevitably continue to rise. Option D present the client with a detailed analysis of current economic indicators, including interest rate forecasts, inflation trends, employment data, and local development plans, explaining how these factors could influence the Ontario real estate market and the potential risks and rewards of purchasing now versus waiting. The correct answer is D. Present the client with a detailed analysis of current economic indicators, including interest rate forecasts, inflation trends, employment data, and local development plans, explaining how these factors could influence the Ontario real estate market and the potential risks and rewards of purchasing now versus waiting. Explanation. Scenario analysis. This scenario presents a professional challenge for a real estate broker in Ontario due to the inherent volatility of real estate markets influenced by economic factors. A broker must navigate client expectations and market realities, ensuring advice is grounded in objective analysis and regulatory compliance, rather than speculation or personal bias. The challenge lies in balancing client desires with the broker's duty to provide informed, ethical guidance under the Real Estate and Business Brokers Act, 2002, REBA 2002, and its associated Code of Ethics. Correct approach analysis. The best professional approach involves a comprehensive analysis of current and projected economic indicators relevant to the Ontario real estate market, such as interest rate trends, employment figures, inflation, and local development plans. This approach aligns with the broker's duty under REBA 2002 to act with integrity and competence, providing clients with accurate and unbiased information. Specifically, the Code of Ethics mandates that registrants must not mislead or deceive any person, and must conduct themselves in a manner that will inspire the confidence of the public. By presenting a balanced view of potential market shifts and their implications, the broker fulfills these obligations, allowing the client to make an informed decision based on realistic expectations. Incorrect approaches analysis. Recommending a strategy based solely on anecdotal evidence or past performance without considering current economic headwinds is professionally unsound. This approach fails to meet the standard of competence and due diligence required by REBA 2002, potentially misleading the client into making a decision that is not in their best interest. Furthermore, advising a client to proceed with a purchase primarily because the market always goes up ignores the complex interplay of economic factors and the potential for market corrections, which is a direct contravention of the duty to provide accurate and unbiased advice. Encouraging a client to disregard potential economic downturns and focus only on short-term gains without a thorough risk assessment also violates the ethical obligation to protect the client's interests and avoid misrepresentation. Professional reasoning. Professionals should adopt a data-driven and ethically grounded decision-making process. This involves 1. Understanding the client's objectives and risk tolerance. 2. Conducting thorough research on relevant market conditions and economic indicators specific to the Ontario jurisdiction. 3. Analyzing how these factors might impact the client's investment or sale. 4. Presenting a clear, objective, and balanced assessment of potential outcomes, including risks and opportunities, supported by evidence. 5. Ensuring all advice is compliant with REBA 2002 and the Code of Ethics, prioritizing the client's best interests above all else. Question 20. System analysis indicates a real estate brokerage in Ontario successfully negotiated a 5-year lease renewal for a commercial property. The original lease agreement, brokered by the same firm, had a commission clause stating a 5% commission on the total rent for the initial term. The renewal agreement is for an additional 5 years, with the total rent for this renewal period amounting to $600,000. If the listing agreement for the initial lease did not explicitly exclude commission on renewals, what is the correct commission amount the brokerage should receive for this renewal? Option A, $15,000. Option B, $60,000. Option C, $25,000. Option D, $30,000. Correct answer is D, $30,000. Explanation. Scenario analysis. This scenario presents a common challenge in Ontario real estate brokerage, specifically concerning the calculation of commission on a lease renewal. The professional challenge lies in accurately interpreting the lease agreement's commission clause, understanding the implications of the renewal term, and applying the correct commission rate as per the agreement and the Real Estate and Business Brokers Act, 2002, REBA 2002. Misinterpretation can lead to disputes with the client, financial losses, and potential breaches of fiduciary duty. Careful judgment is required to ensure fair compensation and adherence to contractual obligations. Correct approach analysis. The best professional practice involves calculating the commission based on the total rent payable over the entire renewal term, using the rate stipulated in the original listing agreement or a subsequent written agreement. This approach is correct because it directly reflects the agreed-upon compensation for the brokerage services in securing the lease renewal. The REBA 2002 mandates that all agreements, including commission arrangements, must be in writing and clearly understood by all parties. Calculating commission on the full renewal term ensures that the brokerage is compensated for the entire duration of the renewed tenancy, which is the service provided. Incorrect approach is analysis. One incorrect approach is to calculate the commission only on the first year's rent. This fails to acknowledge the full term of the renewed lease for which the brokerage facilitated the agreement. The commission clause in the agreement typically applies to the entire lease term, not just a portion of it, unless explicitly stated otherwise. This approach would result in underpayment to the brokerage and a potential breach of the written commission agreement. Another incorrect approach is to apply a different commission rate for the renewal period than what was originally agreed upon without a new written agreement. The REBA 2002 requires all commission terms to be in writing. Deviating from the agreed rate without documented consent from the client is a violation of this requirement and constitutes a failure to uphold the terms of the original contract. A further incorrect approach is to assume the commission is a flat fee based on the initial lease term and not applicable to renewals. Lease agreements often specify commission payable on renewals, and if not explicitly excluded, the original commission terms are generally understood to apply to subsequent terms secured through the brokerage efforts. Ignoring potential commission on renewals without clear contractual exclusion is a misinterpretation of the agreement and a failure to secure rightful compensation. Professional reasoning. Professionals should always refer to the written listing agreement and the lease agreement to determine the commission structure for renewals. If the terms are ambiguous, they should seek clarification from the client in writing before proceeding. Transparency and adherence to written agreements are paramount under REBA 2002. In cases of doubt, it is prudent to err on the side of full disclosure and adherence to the most comprehensive interpretation of the agreement that aligns with the brokerage services rendered.